Good morning or good evening to all of you who are on this HG Plus webinar, and thank you for putting this together for us, Angela. So my name is Lincoln Stone, and I have been an attorney for 30 years, and I have more than 25 years of experience in immigration law, but my experience also includes litigation as well as business transactions. So I will be presenting with you today with the help of my colleague Michael Harris. And Michael is an attorney. His experience is now approaching about 20 years of experience in immigration law, and his practice focuses on business immigration as well as investor and entrepreneur immigration. What we're going to try to accomplish in a very short period of time is, as experienced practitioners in the immigration field, we're going to try to give you a sense for the realities of U.S. immigration practice to allow you to formulate a very realistic sort of plan A for you. And what I mean by that is anybody who's interested in U.S. immigration has probably done online research, talked to best friends and family members about what all the possibilities are, but maybe there is lacking real good, solid information that can be applied to your particular scenario. So hopefully what Michael and I can do is give you enough information in this short period of time to allow you to come up with your very own plan A. Not to say that this is legal advice tailored to your specific circumstances. There's no substitute for actually talking to a real lawyer about the details of your specific circumstances. But you should be able to walk away from this brief webinar with a plan A. You may decide later, of course, after further vetting, that you have a plan B, which is fine. That happens often in life. So why don't we go over to Michael and I are both in the law firm of Stone, Gregoric, and Gonzalez. It's an immigration law only law firm. We're headquartered in Los Angeles, California. It's a rather unique place. We have, in this law firm, an unusual concentration of very experienced attorneys, all expert in U.S. immigration law. Right now we're 19 attorneys. We have about 55 total people working in the law firm. And what is unusual about the law firm is we cover the entire spectrum of U.S. immigration practice, meaning we have experts who are expert in investor immigration, and experts with entrepreneurs, and experts with business immigration. We have experts in federal court practice and immigration court practice and asylum law and family immigration and naturalization. That's what makes this firm very unusual. So let's talk about then what is typically talked about either when you are a foreign student in the United States or you're someone who, let's say, is in China, resident in China, and you're thinking about how easiest to immigrate to the United States here, is that people have considered first off the pathway for employment-based immigration. And that makes a lot of sense. But what I want to point out is that employment-based immigration requires a sponsorship by a U.S. employer. And next, it requires being eligible to fill a job in the U.S. job market. Not everybody who wants a job in the U.S. job market is competitive to be an employee in the U.S. job market. And then what you need to know is that for employment immigration, there is a whole host of rather rigid rules that employers and the employees must abide by. Otherwise, one will be out of status, and that's not going to work well for your long-term immigration prospects. Instead of employment immigration, we have certain alternatives to employment immigration, and what we're most interested, at least in our office, are alternatives that exist for investors and other highly accomplished immigrants. And that's what we're going to talk a bit today after Michael gives you an overview of various employment-based categories. So when speaking of employment-based immigration, and typically with students, foreign students who are in the United States, or even for persons who are resident outside of the United States, say in China, for example, we're typically talking about the H-1B visa category. Why are we talking about that? Because it's a non-immigrant visa category. And we're going to go on to the next slide, where the H-1B non-immigrant visa category is featured. What's important to know is that the H-1B visa category is something that's not so easy to bring to realization. First of all, there's a lottery. There's a lottery because there's more demand for H-1B visas than the US Congress is willing to allocate annually. And presently, the allocation is 85,000 visas annually. This includes 20,000 visas for advanced degrees professionals who have degrees from US universities. And what's really important to know is that for now, the last 6 years, this lottery has been conducted in just a 1-week period. In April of this year, almost 200,000 petitions were received for filling 85,000 positions. And all of those, the USCIS announced within the very first week of April 2017 that enough petitions had been submitted. So there's a lottery. Not everybody who wants to be an H-1B visa holder and who has been sponsored by a US employer is going to get an H-1B visa because of the lottery. The demand far exceeds the supply of visas. Then there's the problem of the timing. The fiscal year for the federal government starts on October 1 of each year, meaning even if the employee is successful with the petition for H-1B visa status, that employment cannot start until October 1 of the fiscal year. The petition needs to be filed in April. As you can see, there's a 6-month delay between the filing and the time that one could start work. This sometimes is a barrier for US companies looking for help right here and now. Very few US employers look for employees who can start 6, 8, 9 months in the future. Then there's the high cost of sponsorship. The filing fees that the US government requires can approach $5,000 when you consider that a lot of petitions are filed with premium processing requirements. Also, attorneys need to get paid, of course, and those fees typically range from $2,000 to $3,000. So you can see that very quickly the costs add up, and we're talking about close to $7,000 in cost to file an H-1B petition. Petitions that might not be approved. Not every occupation is eligible for the H-1B visa. And what is required for H-1B sponsorship is what we call a specialty occupation. That is one that typically requires a bachelor level degree as an entry level requirement for the job. So just as an easy example, not all sales positions are going to be specialty occupations. So this is something that needs to be evaluated very soon in your consideration of an H-1B job. Then not every candidate has the experience or the bachelor level type of bachelor degree that is suited to the H-1B occupation. In the course of employment, there are rigid requirements. The salary is not flexible. The scope of work is not flexible. Moreover, the location of work is not flexible. So these are I mean, this sounds rather negative, but this is sort of all the factors that a prospective employer is thinking about when considering H-1B employment sponsorship. Let's go to the next slide, and I'll just give you a few thoughts about what you might do if you really have your heart set on getting an H-1B employment sponsor in the United States. First, of course, I've already talked about education. You need to have the education and the bachelor level type education that is going to be relevant to the employer who's willing to sponsor you. Then it makes sense, in order to make you appealing to a U.S. employer, that you have practical experience. You could get that practical experience during the time you were in the university in the United States. Michael's going to talk a little bit about that. Practical training, internships, and even volunteer assignments give you the kind of experience that you want to be able to articulate to a U.S. employer who's considering you for a job. Then there are the intangibles like social skills. These are obtained by participating in organizations, networking groups, and getting involved with all kinds of other people, usually on a university campus, for example. Communication skills, unfortunately, are very, very important to U.S. employers. You may have stronger written skills than oral skills. Maybe you need to work on the oral skills. Then I think it's very important when interviewing, once you do get that interview, that you're able to be very, very persuasive as to why you are worth the risk, why you're worth the risk of all those high costs and substantial investment that an employer will make in offering you an H-1B job. And one way you do that is you express a career path that is very consistent with the place where you are going to work. And these are just some of the pointers for convincing a U.S. employer. I'm going to turn it over to Michael, who's going to get into some of the nuts and bolts details with respect to employment-based sponsorship, as well as get us started on thinking about alternatives to employment-based sponsorship.
I'm Michael Harris, a senior attorney here at SGG, and thanks for allowing me the opportunity to speak to you about immigration law. Let's talk about practical training. It is an important tool for the F1 student. It allows the student to gain valuable work experience while still in F1 student status. Curricular practical training, or CPT, is typically part of a degree program. It can also be funded postgraduate research. But typically it takes the form of an internship. The internship can be either paid or unpaid. It can be full-time, it can be part-time, and it can last for up to 1 year. CPT authorization will come in the form of an I-20 approval that is provided by the designated school official. Optional practical training, or OPT, is pre-degree completion and or post-degree completion employment, okay? So OPT can occur before you complete your degree, or it can occur after you complete your degree. And it too is available for 1 year. It too can be paid or unpaid. It can be volunteer employment or self-employment. Anyone engaging in OPT employment must do so in a job that is related to their degree field. This means if you have a degree in engineering, you cannot be employed in fashion design, for example. Also, anyone engaged in OPT employment cannot be unemployed for more than 90 days. If you are unemployed for more than 90 days, you will immediately fall out of status and your F1 OPT will be terminated and you will be required to depart the United States. In order to determine eligibility for OPT, the student must show that they are currently in valid F1 status. They have been enrolled for at least one academic year full-time, and that they do not have prior OPT at the same degree level. This means if you completed a master's degree program previously and used OPT related to that program, and then you entered a second master's degree program, you cannot then use OPT for the second master's degree program. OPT work authorization comes in the form of an EAD card that is issued by USCIS. And it should be noted that students with a qualifying STEM degree, and that's science, technology, engineering, or mathematics, are eligible for a 17-month OPT extension on top of the 12 months of regular OPT. Okay, let's move on to some employment-based visa categories. And we'll start with the most popular for professional workers, and Lincoln discussed this a bit earlier. It is the H-1B visa category. And again, this is a category that is for specialty occupation workers. And what is a specialty occupation worker? It is someone whose job requires minimally a bachelor's degree for entry into it. And two of the other foundational requirements for the H-1B are that the H-1B worker has a degree that is related to the specialty occupation, and that the employer is willing to pay the prevailing wage as established by the Department of Labor. The second category is the E3 visa. And the E3 visa is a sister visa to the H-1B in that it too is for specialty occupation workers. Again, those requiring a bachelor's degree, those who have a bachelor's degree related to the employment, and those for whom the employer is willing to pay the prevailing wage. The E3 visa is reserved exclusively for Australians. However, if you have Australian dual nationality, you should be eligible for the E3 visa. Next is the TN category, and it is reserved exclusively for Canadian and Mexican nationals. The TN is a bit different from the two prior categories in that it is not for specialty occupation workers. Rather, those seeking a TN must look to the NAFTA list of occupation to determine whether or not their occupation is eligible for TN. Not all TN occupations are H-1B occupations, and not all H-1B occupations are TN occupations. Next is the J-1 visa category, and there are many types of J-1 visas, but I'll only address the three that are more common, and those are the J-1 visas for training, for internships, and for cultural exchange. And those entering the United States on a J-1 visa must be mindful that there is a 2-year foreign residency requirement for this visa category. And that means that the J-1 visa holder must depart the United States and return to his or her home country for 2 years before re-entering the United States and obtaining either work authorization or residency here. Next is the O1 visa category, and this is for foreign nationals with extraordinary ability in the sciences, arts, education, business, or athletics. Those seeking an O1 visa must establish their extraordinary ability by submitting documentary support in support of their claim for extraordinary ability. So let's move on to a couple of immigrant categories. The first is the EB1 extraordinary ability category, and it is the big brother of the O1 category that I just mentioned. And it leads to a lawful permanent residence or a green card. One of the most desirable components of the EB1 extraordinary ability category is that a foreign national may self-petition, and that means the foreign national does not require an offer of employment, does not require a petitioner or a sponsor. And eligible candidates for the EB1 extraordinary ability category must show, like the O1, that they possess extraordinary ability in the sciences, arts, education, business, or athletics, and that they will enter the United States to continue their work in the area of extraordinary ability. They must also show that they have not only achieved, but sustained national or international expertise, and that they are at the top of their field. Examples of evidence that would be included in an EB1 petition is nationally or internationally recognized prizes or awards, memberships in associations requiring outstanding achievement of its members, published material in professional journals or major trade publications or major media, evidence of significant contributions to the field, and evidence that the applicant's work has been displayed in exhibitions or showcases, and finally that the applicant was performed in a leading or critical role in a distinguished organization. Okay, and the second immigrant category that leads to lawful permanent residence or a green card is the national interest waiver. And again, a desirable component of the national interest waiver is that there is no sponsorship required. There is no offer of employment that is needed. And the candidate for a national interest waiver must show that they are a professional possessing an advanced degree, a master's or higher, that they will enter the United States to work in the national interest of the United States. They must also show that the work has both substantial merit and national importance. Also, that they are well positioned to advance the proposed endeavor, and that the United States would benefit from a waiver of the requirements of a job offer and a test of the labor market. Okay, and if the candidate has no advanced degree, he or she can establish exceptional ability in the sciences, arts, or business by showing at least 3 of the following: a degree, diploma, or certificate relating to the field of exceptional ability, at least 10 years of experience in the field, license or certification to practice in their profession if one is required, high salary, membership in professional associations, recognition for achievements and significant contributions to the field, or other comparable evidence of eligibility. And I will turn it over to Lincoln for the next slide.
Thank you, Michael. That's very helpful. So having that background, let's talk about a different category which could lead to U.S. permanent residence or a green card, and that is EB-5 investment. It's very important to know that this is a green card generating immigration category. And so when I say that, we should have in mind the thought that it's not going to materialize in something tangible anytime soon. Right now, what we're looking at for purposes of EB-5 immigration generally, given the backlog that exists at the USCIS with pending petitions, is about 2 years from the beginning, filing a petition with USCIS and then getting an immigrant visa and entering the United States. That backlog, however, can be even further, in fact, doubled or tripled in the case of Chinese nationals because of a visa backlog that is specific to Chinese nationals and the visas available to Chinese. This could be alleviated, this backlog that I'm talking about, through an act of Congress to allocate more visas. And that is under consideration presently. The process, though, for EB-5 based immigration then would include a petition that's filed with the USCIS. It sits pending at the USCIS right now for longer than 1 year, but when they finally do adjudicate it, they approve that petition, and then the investor will typically process it for an immigrant visa in the home country. In the case of China, that would be Guangzhou. If the investor is in the United States legally, either in a non-immigrant visa working category like H-1B or in a student capacity, then that investor would not be required to process at the U.S. consulate in Guangzhou, but could pursue adjustment of status here in the United States without having to leave. That, however, is the same sort of timeline that I've already sketched out for you. Once the investor is approved and then commences residence, that residence is going to be conditional for the first 2 years. At the end of that 2-year period of conditional residence, the investor will file another petition. The idea with this latter petition is to demonstrate that the investment has been sustained in the business that was selected for EB-5 investment, and that the jobs that were created. So let's go over, and after that petition is approved, the final petition, then the investor would have a permanent residence without any conditions whatsoever. What are the requirements for EB-5 based immigration? Well, the first one is to invest a qualifying amount of capital. Right now, under current law, the minimum capital level is $500,000. Most of the opportunities for EB-5 investment are at the $500,000 level, but it's important to know they're only at the $500,000 level because they are investments in an area which is considered a targeted employment area, either a high unemployment area or a rural area. If the investment opportunity does not satisfy that rule, then at present, the law requires a $1 million investment. Now, the EB-5 law is under consideration for renewal or change, and Congress, as well as the Immigration Agency, are considering increasing these minimum levels of investment. And the numbers that have been discussed are, for example, $800,000 as a minimum capital investment for targeted employment areas, and either keeping the basic threshold at $1 million or increasing it to as much as $1.3, $1.5 million. There are numerous alternatives under consideration. And it is very possible that these new minimum capital thresholds could come into play in the new fiscal year on October 1. The other requirement that is very important for the investor to consider would be this lawful source of capital. So with an EB-5 petition, the investor is going to have to present substantial documentation to indicate, one, the tracing of the money from a source that is the investor's source, either maybe from family or the investor's own savings or earnings in investments or earnings from employment, and then tracing that to the U.S. business. A third requirement then is job creation. EB5 category permanent residence is available to investors who are investing in the United States for the purpose of job creation. And the USCIS will require evidence that following the investment in the future, in the next few years, the EB5 capital will be instrumental in creating at least 10 jobs in the U.S. economy. I described a few moments ago that at the end of the EB5 application process, there will be another petition to remove conditions. At that time, the investor will have to demonstrate that, in fact, the investment made by the petitioner, in fact, helped to create 10 jobs in the U.S. economy. There's also a requirement that the investor participate in the management of the business that they invest in, but this participation requirement is not a difficult requirement to meet. The investor could be as minimally involved as a limited partner in a limited partnership. I get asked all the time what kind of businesses are suited to EB5 eligibility. And there really is two parts to this. First is one needs to find an investment opportunity that will be sustained. It's important that an investment lasts for as long as it takes to get through the entire EB5 process, which, as you can tell by adding up the various processing times I've described, probably is going to extend beyond 5 years. The second aspect of what is a suitable business for EB5 investment would be that it's a good financial proposition. And this is very important for the person who's considering EB5 investment to get true professional independent advice as to what kind of risk there exists when an investor is putting $500,000 or $1 million or more into a U.S. business. Now, there are some very important considerations that exist for students who may be considering EB5 investment while here studying in the United States. The first one, of course, is the timing of all of this. I've already described that that EB5 investment does require at present a very lengthy application process. If you are a student and you're considering EB5 investment, more than likely for many students, it's not going to be possible to extend your student status long enough to be able to go through the entire EB5 application process. That is, without getting another degree, for example, or without getting an H-1B employment opportunity approved for you. I'm sure there are a lot of people promoting EB5 opportunities to students, but one should not go into that EB5 investment proposition without actually scheduling how it is one is either going to be here legally in the United States throughout that period of time or make other arrangements during the time that the application process is moving forward. Furthermore, there are certain securities laws requirements that are applicable when somebody is here in the United States and is considering a EB5 investment. It's very clear that the U.S. government considers EB5 investment to be typically a security, and a range of rules prohibit the promotion of EB5 investment opportunities to persons here in the United States without following certain protocol. And it's very important not to get involved with a group that is not following that protocol. And obviously, I can't describe all of that right now, but it's very important to know that an investor prospect is going to be asked a number of different questions that relate to U.S. securities laws. Let's go on to the next slide, and I'll leave the EB-5 topic perhaps to some Q&A at the end. There is another investor category. It's a non-immigrant visa. And when I say non-immigrant visa, what should be foremost in your mind is, haha, that's something maybe I can actually get processed much faster than an EB-5 immigrant case, and that is correct. Usually we can set up E2 visa, non-immigrant visa applications within just a couple of months of actually helping a client assemble the appropriate documentation to submit to a U.S. consulate for an E2 visa application. An E2 visa application is typically based on a substantial investment in a U.S. company where the investor is in a position of control and will direct the investment in that company. The timing, as I say, is very critical here, and you can get into an E2 visa category visa much quicker than other categories. It's very, very important to keep in mind, though, that different countries have different reciprocity schedules for the E2 visa. Now, why am I talking about the E2 visa when perhaps many of you on the webinar may be nationals of the People's Republic of China? It turns out that many people who are living in China or maybe consider themselves Chinese nationals, in fact, though, have nationality or citizenship with other countries. The E2 visa is available to only those persons who are nationals of treaty countries. And those countries are, for example, Taiwan and Singapore and South Korea, Thailand, and literally dozens and dozens of other countries around the world which have bilateral investment treaties with the United States. Unfortunately, the People's Republic of China presently does not have such a treaty with the United States, nor does Russia, nor does India, nor does Brazil, which we call the BRIC countries, are very, very large economies. The U.S. does not have treaties with these countries. However, it is possible that certain Chinese nationals may have acquired citizenship in other countries which have E2 visa treaties. And this is certainly something you need to consider when thinking about a non-immigrant visa option for the United States. The last thing I want to mention, and that is because we often get questions about EB-6 or a different type of visa category for entrepreneurs. And I'll just review with you real quickly a proposed rule. This was proposed in the Obama administration last August. It actually was finalized in January 2017, in the final month of the Obama administration. And it is a rule for giving parole, which is allows the foreign national to be here in the United States and to work with a U.S. company. It allows for parole, and as I say here in the slides, it's a 2-year parole, and you can get up to a 3-year extension, totaling 5 years. And it's available for persons who have a greater than 15% ownership in a startup business, and that business has been validated in some way, and that is having received an investment from a venture capital firm or an angel investor of at least $345,000, or having received a government grant of at least $100,000. And it's getting validated in the sense that this signals that the particular startup business has a substantial potential for growth and job creation. So I'm mentioning this to you as an option. However, this option is, let's just say, in a legal limbo, and that is with the new administration, which came into power in February, all regulations promulgated at the end of the Obama administration were put on hold. And this seems to be one of the victims of that new administration. This proposed rule, which I said was adopted as final in January, it actually was adopted in January as final, but not to be given effect until July of 2017. So it actually is not in legal effect at the moment. It is hopeful, and certainly in the venture capital industry and throughout and among entrepreneur stakeholders, it is hopeful that this rule will survive the Trump administration review. But I just wanted to go over this. At the moment, it's not the law of the land. And this will be reviewed at a later time. It'll be very interesting to see if this survives. Now, having said that, I want to just finish our presentation with a few cautions, and we can go on to the last slide. And Michael has touched on, I'm sure, several of these with respect to being in the United States and not messing up your future plan for immigration in the United States. And one of those, of course, is do not work in the United States without authorization. If you're a student, there are opportunities to work in the United States, but there's a very, very strict and clear protocol for getting work authorization. Also, if you're in OPT status, which is part of the F1 visa program, you cannot remain unemployed in OPT status for more than 90 days. Otherwise, you will be ruining your plan for future immigration. Furthermore, there's a very tricky aspect to being in the United States and traveling in and out of the United States from abroad while also thinking about or planning a longer term immigration plan. And you have to be very careful about those entries to the United States. And you probably should get U.S. immigration lawyer advice before you enter the country if you're in that scenario. The things that you really should be doing are, if you are a student in the United States, make sure you do make that timely application for OPT, and you can get that all planned out with the DSO at the university. They're experts in how this works. Work on getting that H-1B job offer, and as you can tell, it's really an uphill battle. Don't expect that you can just go into the job market and throw your resume around and think that you're going to get an H-1B job offer. It doesn't really work that way. Be sure you maintain valid status. Again, the DSO at the university typically is an expert. If they're not expert and they have questions about more complex issues, they will probably alert you to that and say, you know, you really should talk to an experienced immigration lawyer. And know that it's important to take that advice seriously and get outside help. And then I think Michael probably talked about knowing the difference between a visa, which allows you to enter the United States, and then the status, which controls whether you're present in the United States lawfully or not. And these are the important things to pay attention to with respect to U.S. immigration and your longer term plan for immigrating to the United States. Let's with that, let's go to this last slide, and we'll see what sort of questions there might be from the audience. And I'm sure we have at least 10 or 20
We've got one question. Clement just graduated with his master's degree in international business and tax law, and he's from France. And he says, you know, finding a job is extremely hard without the appropriate visa, and even with OPT, most recruiters will, even though they're very impressed by the ability and the experience, they are willing to hire someone who is less skilled because they don't have the same restrictions, because they're not, you know, they don't need sponsorship. So what can I do to increase my chances to a job?
Network, 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 and be able to articulate effectively what the process is for obtaining an H-1B visa. Getting an offer of employment is more than just about spamming your resume out there to the employers. If you can get your face in front of a potential employer and you can convince that person that you are not only competent to do the job, but that you are an excellent fit with their firm, and that you can give that firm long-term options in a particular position, they may be willing to consider H-1B sponsorship. But there's always a fear of the unknown, and not many employers are familiar with the H-1B process, especially for example, engineering managers or VPs or CTOs. Maybe the HR person is experienced with immigration, and particularly with H-1B. So I would suggest educating yourself on the process of H-1B and being able to articulate that to the person who may be responsible for your hiring.
Awesome. Okay, Joseph would like to know, if the president is about to make changes in the current immigration process, what are the steps he needs to take, and what does the timeline look like for it to come into effect?
Well, the immigration process it's pretty complex. I believe it was one of the circuit courts that said that immigration was second only to tax and tax law in complexity. So understand that there are three kind of levels, three levels of rules that apply to immigration law, and there are statutes, there are regulations. Regulations are the rules of the agency, and then there are policies that aren't necessarily written regulations. They may just be a memorandum of how the agency will conduct itself. So all federal agencies are part of the executive branch, and the president has authority to impact policies and even regulations, but after going through a process. But statutes can only be changed by Congress. So, for example, if the president wanted to get rid of the H-1B program, he would not be able to do that on his own. He would have to go through Congress to do that. However, if he wanted to shift focus, move resources from the H-1B program to a different program, that could potentially slow processing for H-1B, and that would have a pretty significant impact on H-1B. And he could change the policies of the agencies and the way that they adjudicate. So that's a fairly simple question to a complex, simple answer to a complex question. There are ways that the president can impact immigration laws, but there are also drawbacks for the president to do that, and there are constituents who rely on not just H-1Bs, but all immigrants.
You may not have a particular opinion on this. This is actually more of an HR question, but when is a good time during an interview process to bring up H-1B sponsorship?
That's a good question. Well, I think this is my personal opinion. I think the sponsorship question doesn't become a question until you have an offer of employment. So I would say secure the offer of employment first, and then discuss the immigration question. And again, make sure that you can articulate what the requirements are for your particular immigration category, whether that be OPT or H-1B or E3 or TN or whatever visa category in the alphabet soup.
Somebody has a question that's kind of interesting. Is it easier to get sponsorship being an entrepreneur? And my one point on that is, obviously, if you're looking for sponsorship with H-1B, that means you're looking for a company to sponsor you, but you can sponsor yourself for H-1B, correct?
That's tricky. You cannot sponsor yourself for H-1B. However, if you are a shareholder in a company, and that company has a board of directors, it is possible for the company to petition on your behalf. Okay. Now, the rules say that you have to be an employee of the company. So let's say that your job is CTO. Okay. But you would have to be able to show that this board can remove you from that position of employment if need be. Okay.
And is that still under the same H-1B restrictions as far as the lottery process if you are on the board of the company?
True, yes. If you have not been counted against a prior cap, you would be subject to the lottery.
Okay. So if you are an entrepreneur and you start your own company, you cannot file for H-1B in that situation unless there's a board.
Correct.
Okay.
Yeah, there would have to be separation between the board and the owner or employee in this case, and there would have to the relationship would have to be credible, adjudicated on a fact by fact basis.
Okay, how important is it to find a job in the exact same industry as my education? I ask this as I was wondering if it has to be for an employer of the same industry as my education, or I have the same industry as a client for the company I work for.
The relationship between the degree and the OPT employment, I assume we're talking about OPT employment here.
I think it could be OPT or H-1B. He didn't specify.
Okay. For OPT employment, it doesn't have to be exact. If you have a degree in mathematics, you can work in a computer-related job. If you have a degree in engineering, you can work in a computer-related job. And the same is true for H-1B. It's more relaxed for the OPT worker than it is for H-1B. H-1B, you'd have to really establish the relationship. You'd have to look at the academic transcripts. So you'd have to take a look at the academic transcripts and take each course and show how it relates to the employment. And if you can do that, you can be successful even if the degree seems somewhat unrelated by title. Working as a consultant would not work for H-1B in an independent contractor capacity. That person would have to be working for a consulting agency, and if they're working for, say, a tech company, those cases are scrutinized when the H-1B worker is working off-site. So those are also much more complex H-1B petitions than your typical H-1B.
How much does it cost for the company to sponsor someone, and can I pay my own way to get sponsorship?
You can, unfortunately, the H-1B beneficiary cannot pay for any part of the process, unfortunately.
Including the legal fees?
Including the legal fees. They may be able to pay for premium processing, which is expediting the adjudication process by 15 days, but they cannot pay for anything else. And the fees right now I believe there's a Form I-129 filing fee of $425. There's an anti-fraud fee of $500. There is an employer filing fee of either $750 or $1,500, depending on the size of your company. And then if you want 15-day premium processing, you're looking for an additional $1,225, well, $1,225. And then there's the legal fees are separate.
Sarah wants to know,
Okay.
how long in advance will the company need to start preparing the paperwork if April 1st, if the lottery starts in April, how far in advance do they need to prepare the paperwork?
We typically, here at our firm, we typically want to have everything in our hands by the first week of March. But I would suggest we start the process in January. That way, we're not putting ourselves in a precarious position if, for example, the online site for filing the labor condition application becomes inoperable for some reason. We want to make sure that we have our labor condition application certified well before we file our H-1B petition.
Okay.
And we want to make sure that there are no hiccups along the way. And this is, we don't want to get down the road into mid or late March, finding out there are problems with the petition and potentially risking not being able to file.
And is there any particular document that takes the longest amount of time, or that's a significant amount of time they should be aware of?
Well, the labor condition application, or LCA, that takes up to 7 days. And if the company has not previously filed an H-1B petition, then we probably need another 3 days to get the company certified with the Department of Labor. So that's probably the longest process. There may be other issues. There may be degree relation issues. There may be, or maybe the person doesn't have a bachelor's degree and they have to rely on equivalency. So they're using part of their experience and their degree to qualify for a U.S. bachelor's degree. That is the case where we would have to send the academic records and the experience records off to an expert to evaluate, and that could take time. And as you can imagine, in March, the experts that do these evaluations are inundated with cases. So I would suggest having the analysis for something like that done very early on in the process. Thanks for having us.